So, in what is being touted as a win for Anthropic, they have won kind of in a court case around fair use in regards to their training materials. And the actual ruling from the judge is very readable. I had a good time. It's about 32 pages long. We'll link to it in the description. I think I want to format this segment where I want you to ask me any questions you have, Perry, but I will first lay out the situation at hand. Anthropic needs a lot of training data. Every LLM creator needs a lot of training data, specifically a lot of cleanly organized, written, high-quality text data. A great source of that, obviously, is books. There are loads of books that are in the public domain and available for free, so you can bet your butt they gobbled those up. And then they also used a lot of copyrighted works that are not in the public domain, that are not free, a lot of which, they pirated using like Library Genesis, LibGen, and other things. And then they hired on one of the guys who helped orchestrate Google Books and has a lot of more familiarity with copyright around this kind of thing, who then brought more books into it, but by purchasing them legitimately and then destroying them, tearing off the covers, cutting the pages to size, scanning them, digitizing them, and cleaning the text for search and storing them inside their internal private library. So the question was, what of this is fair use? Is it fair use to buy a bunch of paper copies of books, tear the covers off, digitize them, and use them? Is training AI transformative? Does it fall under what constitutes fair use? All of those questions were answered in a very interesting way. And I want to lay out what fair use is. I'm not a copyright lawyer, but I had to do some like rudimentary copyright training when I was in radio, and I think it's a fascinating subsection of the law, or a subset of law, or whatever. Like it's a fascinating area of legality. I'm not a fan of our copyright system, but fair use is when you can take something that is copyrighted by someone else and use it in a way, like use it for your own thing. And there are some strict stipulations around that, namely that it has to be like for commentary, for educational purposes, or wholly transformative in some way that it is not really the original work, copyrighted work anymore. And the way that this is determined in court is by what is called the 4 factors test, which the judge has to consider the purpose and character of your use of the copyrighted work, the nature of the copyrighted work itself, the amount and substantiality of the portion taken, and the effect of the use upon the potential market. And that last point is the one that I feel like often gets the most weight. If you want like a quick mental shortcut of like, am I going to get in trouble for copyright infringement? Think, am I taking money that would otherwise go to the copyright holder? So those are the 4 factors that were used to measure in this case. Perry, I've said a lot. Do you have any questions?
I don't think I have any questions. There's one quote that I've seen thrown around on all the social media channels from that 32-page document is what you said.
Yeah.
Is that right? And the quote that I keep seeing over and over and over, people cut and paste, is the judge saying, extremely transformative in nature is the thing that I keep remembering, is that the judge's ruling was that they believe that the way that Anthropic was ingesting that data and then creating new unique outputs based on prompts, what it qualified as being extremely transformative.
Yes, and that is sort of the biggest takeaway, I think, for everyone but Anthropic, is that this judge, and also there's some caveats with this, but yes, this judge...
But it should make OpenAI and Meta and everybody else really, really happy, right? They're feeling like they can maybe save some legal fees going forward.
I think it's showing that you're not still in hot water if you've purchased original copies and used them for training, because what the judge ruled was that all of the stuff they pirated, absolutely not okay. You can't pirate it. So like that was out of the question. They're going to be on the hook.
Oh, darn.
Yeah. Oh, no. Oh, man. And that same thing with like OpenAI.
What if you do your training in a country that doesn't have as strict copyright laws?
Now that I don't know, because this judge didn't even touch on that, because this was just a U.S. judge.
That's what I'd be asking.
Yeah, can we just offshore this whole thing in like Japan, where copyright is a completely different animal?
Yep.
So the judge ruled that the use of these copyrighted materials to train an AI is a wholly transformative process because the input here, the copyrighted input, is not substantially reproduced in the output to the consumer. So that is sort of the essence of what the transformative nature of it was. And again, purpose and character, the nature of the copyrighted work being a text versus, the nature of this, where it is used, being to generate an output based on the semantic patterns in it. The judge really pretty firmly came down on the side of training an AI is a lot like a writer learning to write from reading other books. Right. Because, you know, if you copied a book wholesale, you copied a book wholesale. There are some holes that are going to be poked in this, though, because the judge... Well, actually, I'll quote from, there's a Fast Company article that I thought captured the nuance pretty well, which we can share here. The fair use ruling looks bad for creators on its surface, but so this is their opinion, saying that this looks bad for creators. I'm not really sure that this is bad for creators necessarily, because it just shows that, like, if you have licensed training material that you've paid for, you can use it. But anyway, the quote from this Fast Company article. The fair use ruling looks bad for creators on its surface, but this is far from the final word on the matter, says Ed Newton-Rex, former AI executive turned copyright campaigner and founder of Fairly Trained, a nonprofit certifying companies that respect creators' rights, which I believe we covered on an earlier episode. It's a cool thing he does. Newton-Rex sees weaknesses in the ruling's reasoning, saying, quote, the judge makes assertions about training, not de-incentivizing creation, and about AI learning like humans do that feel easy to rebut. He says, this is on balance a bad day for creators, but just the opening move in what will be a long game. While the judge approved training AI models on copyrighted works, other elements of the case weren't so favorable for Anthropic. Andres Guadamuz, whose name I might be pronouncing wrong, is an intellectual property expert at the University of Sussex and is quoted here as saying that the judge Alsop's decision hinges on a, quote, solid fair use argument on the transformative nature of AI training. The judge thoroughly applied the four-factor test for fair use, and the ruling could reshape broader copyright approaches. We might start seeing the beginnings of rules for the new world, he says, where having legitimate access to a work would strongly... The writing here is confusing. We may start seeing the beginnings of rules for the new world where having legitimate access to a work would work strongly in proving fair use, while using shadow libraries would not. So the ruling basically outlines that if you can prove that you purchased an original copy of this book, even if you tear off the spine and digitize it, because in that case you are not making any additional copies, you purchased one copy, you used one copy.
Right.
Which gets complicated with Anthropic's library and who had access to it and how they didn't want to disclose that. But putting that aside, proving that you bought a copy and used it as part of your big corpus of training data is enough to win a fair use case in the U.S. So that would make companies like Meta and OpenAI want to scramble to be able to say, we paid for this, we licensed our training data.
Well, it's interesting that, like, the purchase of one copy is a thing, because at that point you're treating this multi-server instance of something that can talk to millions of people at a single time as a person, right?
I mean, it's like,
which is,
think about like ebook lending, right? That's been a weird copyrighted area. The Internet Archive got in a lot of trouble for that because of the lack of controls on who has access to any individual copy of a book. What is a copy when the file must be copied to be read, essentially, over a server infrastructure?
Yeah, exactly.
And yet this judge did come down in favor of saying that this case was fair use. All the books that went into training the LLM, having that library, that corpus that they used as a source of training data is enough to qualify for fair use because the input is not substantially reproduced in the output to the consumer.
Unless you're the New York Times and you're trying to trick ChatGPT into giving you output, right? Because that's the crux of their case against OpenAI, is that they had reporters that were able to go in and prompt sufficiently that big chunks of text from their previous works had come out. But you kind of, that's not, I don't know that was like done in good faith. I think trying to trick the system into doing that is a different case. There's
a nod to that in the case. At one point, the judge mentioned, not the judge, I think it was part of the information discovered in Discovery, where they talked about, the model could reproduce a lot. If you prompt it for it, you can get it to reproduce a lot, pretty close to verbatim. But the judge ruled that is more akin to quoting something you're really familiar with, that you have like learned. And it's not that the purpose of the AI system is not to produce that same output or to copy the book out to the user. And in fact, it would be difficult to copy a whole book, to distill a whole book back out of an LLM.
Exactly.
Which is why he came down on the
or even an article, right? Because of the way that the embeddings would work. Is you can't guarantee that something verbatim would get stayed or it would get stored in a way that you would like auto regress that output out.
Yeah, and I think like reading through it, it all really it hits the mark for me as far as like common sense application of copyright law to this. I think it's interesting that the Fast Company article frames this as a bad day for creators, because what this says is like, if you legitimately pay for and license training data, then you can use that for AI instead of stealing everything like people already have done. I don't see how it's bad for creators, really, because I think
they're hoping that maybe the scale of the licensing would be bigger. Like,
probably
if you pay $20 for one book, and then Anthropic and Meta or OpenAI or somebody else is able to then derive a whole bunch more than a normal person would be able to get out of that.
That is also mentioned in the court case, because when you talk about the effect on the market as part of the 4 pillars test, or the 4 factors test,
right.
The judge said that it would be kind of unreasonable to try and charge someone more based on them doing something exemplary after using your work as part of a learning process.
I mean, when I think about it, it actually makes sense. So I'm going to argue against the thing that I just said, because let's say you have a really, really like tuned in personality that has a huge audience of millions of people. Somebody on a major network or celebrity or somebody like that. And then they read a book. And then they form some opinions and start, talking about things based on what they had read. It's very similar to that, maybe in the judge's mind.
I wish I could have the exact quote pulled up, but I read it on my phone like a crazy person, zoomed in on the PDF.
Oh, yeah.
The judge said something like that, like you can't expect to then charge someone more money for that because of that. I wouldn't be surprised if we see some kind of a shift where maybe publishing houses license larger corpuses of data already digitized and ready for you at a higher price for convenience and service. Like, there might be other things around that, but at its base level, what this judge ruled on, at least to me, seems to make common sense and not really be bad for creators. And also, Anthropic now has to go to trial for so much potential damages. This Fast Company article says, yes, they pirated more than 7 million books, and that alone could carry billions of dollars in liability, with statutory damages starting at $750 per book. A trial on that issue is still to come. So these companies might be seeing their comeuppance for stealing a bunch of training data, and also there is now a one-judge legal copyright fair use precedent for training on data being transformative and falling under fair use.
The thing is that all the other companies are going to hear that, and then they're just going to do math and go $750 per book is like the worst outcome. How many books were in that corpus? Did you say 700,000?
7 million. So the scale here might actually be enough. This is the problem with using monetary penalties against massive corporate entities, right? Is that a lot of them will see a fine as just the cost of doing business rather than any punitive measure to stop their behavior. But 7 million books at $750 per book.
$5.25 billion.
5.2 if it's $750 a book.
Yeah. I mean, but then you negotiate it down. I mean, I would say if they're looking at $1 billion or $2 billion for this, they would say it is cost of doing business.
What about Meta and OpenAI when these kind of cases come their way too? What are they going to see? And this isn't
Meta, that's a drop in the bucket.
That's true.
Yeah.
We need these precedents. We need laws and regulations about this. And it needs to be enforced in a way that is actually enforcing it and not just
that like really hurts.
Because again, this is just for a handful of authors that were taking Anthropic to court based on their books being used to train Claude. So this is just like the opening volley of what is going to be a wild saga of copyright law.
It'd be interesting to watch.
Yeah, and it's if you're really boring on the inside like me, and you want something fun to read for a boring person, you should read the ruling. It's interesting, and it's also snarky. And there's I don't know, it was like watching an episode of Law and Order, but on the paper. But maybe that's just because I'm really invested in these topics. Who knows?
Nice. All right, let's go to the last segment, I guess.
Oh yeah, this week's AI dumpster fire of the week. Is that right?
Yeah, and it is a dumpster fire. So it hits on a couple of things we've already touched on, so I don't want to give too much away, but get ready to get dumped on.
Oh, boy.